Good morning, ladies and gentlemen. We will now start with the first panel, which is on general issues of international law concerning the war in Ukraine. My name is Stefan Oeter. I'm a professor of public international law at the University of Hamburg and principal investigator at the Minerva Center for the rule of law under extreme conditions. And I've agreed with the organizers to start for setting the scene with some brief remarks on the use of Bellum side of the war in Ukraine. I can be brief because it's a rather clear-cut case. One can say as an international lawyer, and it's not hazardous in saying that the Russian assault on Ukraine is a blatant war of aggression. Let's say, evidently going against one of the iron rules of international law, the prohibition of the use of force. And it's, I can say, that's not a simple violation in the sense of the state responsibility, but it's an international crime, a crime of aggression. And one must add that this is independent of the Kampala Compromise, which made operative the aggression article in the Rome Statute, because the crime of aggression was already well, not invented, but inserted in the Nuremberg Statute in 1945 on the initiative of the Soviet Union, one must say, which at that time insisted on doing that. And I think there are good reasons why in 1945 in Nuremberg people were talking of aggression as the supreme crime. Because if you are looking to the war in Ukraine, you can see why. Setting in motion a spiral of violence and bloodshed as such a war of aggression sets in motion is in a way a much more blatant crime than the individual war crimes and crimes against humanity which may be committed in the course of the war. They are kind of ugly enough if you look to Bucha and now to Izium, but I think we should first bear in mind this issue of the crime of aggression. And one must say, I've had a lot of discussions with political scientists and journalists in the last months, well, and also with some colleagues from the global south. Well, what's the difference? The US also blatantly violated the use of force in Iraq when making a war of aggression. I would say that there's I would say there is more in the case here at hand, because Russia also, let's say, goes along with an attempt at grabbing land by force, which is even more going against the grains of modern public international law, the prohibition of forcible acquisition of territory, which was also already kind of the first claim in that direction was already the Clemson Doctrine of the 1930s, following the Briand-Kellogg Pact. This is one of the, I would say, most important civilizational achievements of the development of international law in the last 100 years. And upholding that is of primary importance for the international legal order. Russia is completely negating that. It has already negated that with the annexation of Crimea. And now it's even going forward with Mr. Putin's claim that Ukraine is not a nation which deserves the right of self-determination. It also shows a clear disdain for self-determination as one of the basic principles of the UN Charter. So it's going even beyond the war of aggression. I can say at the same time, there's clearly no justification of that use of force. If you look into the half-hearted Russian attempts at justifying, in terms of legal discourse, the use of force, it ends up in a kind of parody of international law. It's difficult to take it seriously and not to ridicule about it. And in that sense, and I would be kind of interested to find any serious colleague of international law who would seriously try to defend it in these kind of in this discursive frame. In that sense, I think that's the part I can already kind of give over more or less. It's a very clear-cut case, and I've discussed it a lot with colleagues of political science. The question: what does it mean for the integrity of the system of international? It was the issue Gani Barzilai raised in his question, the faith in the international legal system. And there you can say, at least there's an important current in political science and international relations insisting on, well, the fact that international rules of international law are violated is not uncommon. The integrity of the international legal order depends on the reactions of the others, or of the legal community, because it's a decentralized legal community. Upholding the legal order depends on adequate reactions of the legal community, which means scandalizing the breach and trying to resist, to create some resilience of the legal system. And that's in a way the topic David Kretzmer will talk about. I cannot resist of giving one short remark on that. It's a topic where I could never have imagined that it would come as a practical topic anymore. I must say, in the sideline, I wrote my PhD on that topic, on the topic of neutrality and non-belligerency and the question of arms transfers to belligerent powers. It's a debate which in essence came up after 1990, in the creation of the first attempt of creating a system of collective security, where at that time there was a huge and vivid debate. Is it possible in a system of collective security to remain neutral when the system depends on the solidarity of the members of the legal community in upholding the collective security? And can you, if you're not assist the victim of aggression by collective self-defense, which in a sense would be nearly, at least in a strong sense of collective security, would be a moral obligation. If you don't do that, you at least cannot stand aside and behave as if there is no legal problem. This is the whole figure of non-belligerency, which came up in the 1920s. It was interesting to see how that debate, for some weeks in March, was led very vividly in Germany. Fortunately, our government took the right position, and I think the colleagues in the Foreign Office also had an idea. Perhaps they even looked in my book, but it's not the only one on that. So in that sense, it's a sideline of this question of resilience and how the other members of the legal community should react on that. That should suffice for setting the stage, and I've already kind of intruded to a certain degree in David's topic, so I give the floor to him now.